Adjournment request, if any, from item number 1 to 13.
Please, Lord. Yes, I have to mention item number 12, Lord.
Well,
Yes, Lord. We have already circulated an adjournment slip.
general sleep business.
Okay, 2 weeks time we will grant.
Give the dates according to the.
22nd June.
Hello, Lord.
May it please your lordship, with regard to item 1 and 2, I have filed the adjournment TCS. Yeah.
You also, no? So to be able to-
1, 2, 1, 2,
and 3.
Yes.
17th July. From item number 14 to 20.
May I please your lordship, with the consent of the other side, I beg to mention item number 14. I have circulated the adjournment slip.
Much obliged. 15 June.
Is it coming for the first time?
Yes, lordship.
Also, we'll issue notice. 535 days delay. We'll issue. Why do you want adjournment?
Your lordship, I am not the conducting counsel.
You may not be. Don't ask for an adjournment. We'll issue notice. Whether we condone the delay or not, that's a different thing altogether. We'll issue notice.
Okay.
Just remind us.
Yes, sir.
I did forward.
Yes.
Much obliged.
Item 21 to 32.
May I please your lordship? Lordship, I beg to mention, my lord, item number 22, my lord. My lord, it may be, my lord, the first week of June, my lord.
Don't insist for that. We want an adjournment. We are granting you an adjournment, but we will say it from our calendar. Next.
19 June.
19th, my lord. My lord, 19 may be difficult. 12, my lord.
Yes.
Hold on.
27 July.
No, please, your lordship. Item number 21, I beg to, I pray time for filing additional affidavit. Your lordship.
You are unnecessarily delaying it.
No, your
It's a
lordship,
simple prayer with respect.
your lordship,
Fine.
my lordship, that is certain.
Just a minute, Mr. Kalsi, you are an advocate.
Yes, your lordship.
The other associate of yours is also an advocate. Now, it's a case of, the impression gathered was that it was a ghost file.
But the reality is this. The reality is, I'm not the author of the wrongdoing.
So let it be argued, no?
That is additional certain facts are turned up. I want to bring that on records, your lordship. Just a 2 weeks time, it is a matter of, it is
How
a,
do we permit you to do that?
your lordship.
In appeal, just a minute, Mr. Kalsi, in appeal, you went in review with all those facts. I think you are referring to some caveat petition filed by one of the respondents against the person who is non-existent. Is that correct?
Your lordship, certain grounds have not been taken in the previous, in this appeal. I prayed for bringing those additional grounds on
Just a
the
minute,
record.
Mr. Kalsi, let us talk like professionals. Now, you are an advocate. The single judge has passed certain observations, certain comments, which may not be charitable so far as you are concerned. Now, the only prayer would be nothing else. You're not asking the case to be revived. The case filed by the petitioner for probing for judicially monitored probe with respect to death of a DSP. Correct? So it is only your personal thing that is there. It is only for this that you filed an appeal. So your prayer would be for not proceeding against you. Maybe you
But additional to that, there are certain other facts are also there which are not but on the grounds. Your lordship, it is a matter of a reputation and integrity of a advocate. This is the precious, that is the integrity and the reputation is
Perhaps
the
you're
only.
not understanding what the court is hinting. I think we are inclined to avoid that observation against you.
But
Apart from that, let it remain whatever it is. We'll not interfere with the dismissal of the writ petition. You're not concerned. You want time.
No, Your Lordship, that is not my prayer. Mine is only my reputation and integrity. I'm just emphasizing on that. Because actually, I was not contemplating that this consequences will fall upon me.
No, but what do you want? You want a, you
2
want a
weeks
set-
adjournment, Your
you want a
Lordship.
set, you want an adjournment, let's.
I
keep
want
going.
an adjournment,
All right.
filing an additional
As
affidavit.
prayed for on behalf of the appellant. Does this matter come up for consideration? August.
In person. In person.
24/8,
24
August.
August. It is
All right.
long. It can be shorter also. I don't mind. August.
Let it come in order.
Lordship, sir, they to mention item 26 of this list, daily list. Lordship. This matter I appear on behalf of Mr. B. Sharma for the respondent. Lordship.
So 26 goes with, no, 26 dollars. All right, what do you want?
Lordship, I pray for an adjournment for today. Lordship.
As prayed,
Lordship, I am for the applicant.
as prayed for on behalf of the petitioner. Let this matter come up for consideration under the same heading for the date in July.
27 July.
Nice, Lordship.
Your Lordship. That is like being fixed on 24th. 24th, I will not be there. It may be a bit earlier.
Give another date after 24.
26,
Let it be 27.
27.
May it please your lordships. Lordships, we have circulated an adjournment request with regards to item number 27 to 35, your lordship.
What proposals this matter about?
Lordship, the matter relates to allotment of a tender by the Animal Husbandry Department, where we were the L1 bidders and we had almost completed the work. But an observation made by the learned single judge by the impugned judgment and order, it was held that that the work may be completed by somebody else, just in case it is not completed by us.
You have already completed the work, no?
We are 80% is done.
If you're not completed the work, then the matter would be assigned to somebody.
80%, 85% work is.
So rest 50, therefore.
There is a stay,
As paid for, as paid for on behalf of the appellant. Let all these matters be listed on things in August.
But we have also filed, our appeals are also there. State has also filed appeal against that.
Where is that?
It's listed, item number 20, item number 20. I need a shorter date, Malab. The work, the final work is not.
Is there a stay order?
There is a stay order, the single bench order, but the contractor is not doing the work. We have instructed him to finish the work because
Syndicate says what?
the single judge has said that the work should be done by some other person, not by the contractor. The Lordship has stayed the order. The contractor is to complete the work. We have instructed him.
State the order.
There is a interim order.
By this court?
Yes, ma'am.
No. 24. No, we can't, it can't. With respect to infrastructure works, we don't stay. We decide the matters, we set aside the orders, but we don't.
Lordship may kindly take up the first case.
But would you be interested in allowing him to complete the work?
Well, we need the work to be done. We need the work to be completed.
done.
Yes.
So we will give a direction to them that if they don't complete the work by a particular date, we'll give them timeline.
Lordship.
And then
Lordship.
it will be open for the state to retender it.
Yes, ma'am.
There's
Yes,
no-
yes.
Why do you want time? We'll pass that on.
11.
Lordship, in
They should-
case, in this
they should
case, the
complete the
CA is
work.
not here, your lordship, so I'll have to take instructions from him, your lordship.
25/11.
All right, but we keep on- No.
Kindly see the order dated 25/11/24.
Lordship will take it sometime in next week, your lordship.
The predecessor court has stayed.
So,
So
And-
this stay means the order does not have effect, does not take effect at all.
so they have
In that case, he's also not under an obligation to complete it.
no,
So we will not give a long time.
Lordship.
Tomorrow, day after tomorrow,
Malo.
next week,
Lordship, in the first week of June, your lordship.
why first week of June?
Lordship, my senior Mr. K.N. Chaudhary is out of station, your lordship. He's not on Indian shores.
As prayed for on behalf of the appellant. let all these appeals be listed on first week of June. All right.
4th of June.
Much obliged. Lordship, I believe the interim order may be continued. Your Lord.
We will not say that
Lordship.
unless it is specifically revoked. We'll not.
Lordship.
No, we are not interested even in granting adjournment because you're not completing the work. You're not allowed them to sort of because of that order. It is not being put to regender. That's something which we don't approve of.
I will seek instructions from my client, Your Lordship,
Yes.
regarding.
Complete the work. Give us a date timeline. We do whatever you ask.
Lordship, much obliged.
Yes, please, your lordship.
Yes.
I beg to mention item number 24. The senior counsel of this matter is engaged in another matter, urgent matter in Itanagar branch. So another date may be given.
Anyway, no, we don't entertain private disputes. Anyway, as prayed for on behalf of the appellant, let this matter come up for consideration in August.
A date may
Are
be.
you aware of the facts of the case?
Yes, I am aware, but my senior counsel will argue on a matter.
All right, we will not discuss the petition in the absence. It will not go on your head, but then you have lost in the title suit. You have withdrawn it. There is no liberty.
The matter was disposed by single judge.
Matter was disposed of, therefore you have come here and appeal. Anyway, then August.
7 August.
Much obliged.
Item 36 to 42.
May I please your lordship? Lordship, I beg to mention item number 36, lordship.
As prayed for. On behalf of the appellant. Adjournment slips are related, Samantha.
Obliged.
Take the date.
4th August. Any other request? Daily list for orders item 4 and 5.
Yes, Mr. Advocate.
Lordship, this is a review application preferred by the state of Assam against the judgment and order dated 14/3/2024, which Lordship will find at page 36. The basic facts before I go to the judgment is that from 93 to 98, there were large-scale communal violence in Bodoland area between the Adivasi and the Boru areas. And a lot of people were uprooted from their villages and reserve forest also. And they were all initially given shelter in the relief camps. Immediately, few of them have left because they are well protected and they do not suffer from the insecurity of livelihood as well as life. Some remain back in the relief camp for about 12-13 years, and the government found it very difficult to sustain them. Those who have had landed property, they willingly went back to their, some with additional security also, but a fourth group of people, they were remaining there. At that point of time, a government decided that 10,000 rupees will be given to all inmates of all affected persons.
Yes.
When the final group of persons who were not being able to go to their home place or they do not have any landed property also, then the government has found it very difficult to maintain them day in and day out. And therefore a committee was constituted in 2008. And thereafter, a lot of deliberations with the then chief minister, and finally a policy was framed that during the deliberation, it was also mooted that whether land can be acquired for them or purchased for them and give it to them for their rehab. That could not be done because it was a long-drawn process. Finally, government decided that to that particular group of people, 50,000 will be given to them so that they can take that money and purchase land wherever they want. Because some other nearby districts are also objecting for their en masse settlement there. So they can spread over the whole state. That was the policy. I'll place everything. a narrative was created by those persons who left the camp immediately or within a period of 1 year, 2 years. They were entitled for 10,000 rupees. They created a narrative that government has enhanced the amount from 10,000 to 50,000, which is totally incorrect. And that was accepted by the Honorable Learned Single Judge as well as by the division bench. The main facts which are part of the records were never deliberated.
Let notice the issue. The respondents. Who are they? Respondents?
This group, Relief Families Welfare Service Society and others.
The issue to respond, we have this. The judgment not that it's going to go past also. Let notice the issue. On the steps taken by the applicants slash state within a period of 2 weeks, both modes returnable. You are appealing for.
Lordship, I appear for BTC, my lord, and for respond number 28.
So we'll take steps.
Notice to PTC is accepted by Thomas so and so. The rest others on steps to be taken by the state within a period of 2 weeks, both modes returnable. August.
Lordship, I am paying for stay of this because there is a contempt proceeding also going on.
Whenever
Operation of this may be.
oppressive action is taken, you come before us, we'll stay.
Already we are facing that problem.
Make a statement before the concerned authority that this review petition is pending, notices have been issued. Please hold on. If they don't do anything, if they proceed further, if it is further.
Then I'll come before this.
Come back with a 2 pages affidavit, we'll stay.
Highly obliged.
Plus,
Highly obliged.
The other side, because see, they are destitutes. So,
No.
I mean, that is
Yes.
the
That
record
is-
says.
Yes.
So if you take away something from them, they must be heard. You're right. This 50,000 thing is a narrative which is
Wrongly created.
wrongly created. We'll rectify it, but only in their presence.
Highly obliged, Lordship.
10-8. Item 6.
May it please your lordship, in this matter, notice was not yet issued due to the pendency of the SLT before the Honorable Supreme Court. Still pending on 22/5, it has been listed.
22/5 it is
Yes,
listed
yes, lordship.
as great for behalf of the petitioner. Let this matter come up. August.
12 August. Item 7.
My lords, for the item 7, I'm appearing for the applicants, and we have since filed our affidavit of service for the, we have taken step by way of paper publication, my lords.
I will give some more time for them to appear because it's a substituted service of notice. So we will.
All right, my lord,
We'll wait for the other respondents to appear. 1, 3, and 4. No, 1, 2.
my lords.
Awaiting the appearance of respondents number 1, 3, and 4, who have been served, for whom paper publication of notice has been directed for. Let this matter come for expression. Or sometimes after 3 weeks. In that case, if they don't come up, then it's a 36 days delay, no? 36 days delay, Mr. Counsel.
Yes, your
30
lordship.
days, my lord, yes.
So
Yes, my lord. Yes, my lords.
All right. 3 weeks.
Highly
Lordship.
obliged, my lord.
17th June. Item 8.
The justice service has been completed, my lord.
Have you filed that affidavit?
Affidavit, my lord, I'll file it today, my lord.
Mr.
H. Gupta.
Mr. H. Gupta, learned advocate for the applicant slash union of applicants slash union of India and 6 other suffrages. That the affidavit with respect to justice service of notice, response number 1 to 72 shall be filed in the registry by during the course of the day. Let this matter come up for consideration. Or after 3 weeks.
I'll look.
15 June. Item 9.
May please, the service is complete in this matter.
Has the bank been served? Any designated advocate for the bank, HDFC?
M. Sharma.
Go ahead.
M. Sharma appears.
I do not know. I'll have-
Can you just inform Mr. M. Sharma? We are passing it over. This matter would be listed tomorrow. This matter would be listed tomorrow. Ask if you, Mr. M. Sharma,
M. Sharma.
ask Mr.
Mukesh Sharma.
Ask
Whether
Mr.
he appears for HDFC, just ask.
Whether he appears or he doesn't appear, he has
This
got no
Mr. Sharma
instructions,
is-
but
Sharma is
let
there.
him, let him.
Mr. Sharma is there, sitting.
Yes. Are you the advocate for HDFC Bank? It's a delay of 24 days. We are inclined to condone it. We have only issued notice
Oh, yes,
because the prayer for
agency
condonation
is
was
DRT
rejected
matter.
by the court below. Huh?
It is DRT matter, yes, your lordship. I am handling in DRT.
So accept it,
HDFC.
Yes, sir.
accept it, take instructions, come back to us tomorrow.
Yes, sir.
Give a copy.
Yes. Okay.
There's this matter also. So they have to.
22nd. 22/5. Item 10. Not office.
One more opportunity.
Yes.
Awaiting the report regarding service of notice on response number 1 and 2. The matter is again adjourned to give a date in July.
28 July 20. Item 11.
Yes, Mr. Chaudhary.
Mr. My lord, kindly come to page 150, my your lordship's order.
Yes.
Last but one paragraph point, I am only on that point. Rule 46(3) and section 18 do not run counter. And for any meeting of a Gau Panchayat, the quorum would be 1/3 of the total members.
Yes.
My humble submission is rule 18, section 18 is different point. Section 18 is for the first time and 46(3) come to administer oath, and in that meeting, quorum is there, mother, 3 is there, man. So, your lordship,
It's not a matter of review. You challenge it before a superior court.
mother,
It's not a matter of review. You challenge it. This is.
no, mother, I
This should amount to re-hearing.
we have said interpretation clarification also. Mother, my,
Mr. Chaudhary, it would amount to re-hearing of the matter. We have given a definitive finding that the perforce the provisions of Rule 46(3) is to be read along with Section 18 of the Assam Panchayat Act, which provides the quorum and the procedure for meeting of Gaon Panchayats. According to Section 18 of the Act, the quorum for a meeting of Gaon Panchayat shall be 1/3 of the total number of
Right.
members.
right, mother.
Therefore, 46(3) and 18 do not run counter, and for any meeting of a Gaon Panchayat, the quorum would be 1/3 of the total members. This is what we have read.
Yeah.
Now, if you ask us to review our opinion, I think it does not call
No,
for a
no,
review.
one thing on my lord,
Asks for, just a minute, Mr. Chaudhary, you may be right, we may be wrong,
my lord.
but then not a thing to be rectified in review. We go before a superior court. And we'll have a real.
Let us see if I convince your worship, my lord. Only one thing, my lord. That section 18 comes only when Gauhati constitution fully, my lord. Because under section 6, my lord. And section 43.
Let notice be issued. Palal, this the applicant, the petitioner has filed the present application for reviewing the judgment dated so passed in February number 12. Let notice be issued to the respondents on steps being taken by the petitioner within a period of 3 weeks, both modes returnable August 10.
Obliged, boss.
26 August.
I think there are subsequent, some orders subsequent to this.
We have passed many orders on this presumption of law.
But in my opinion, I think your worship.
See,
not
we
further,
will
my
put
lord.
a stamp of
Maybe.
approval on what we have said.
Maybe my lord, section 6 comes, my lord.
All right.
Obliged.
It'll be easier for you to challenge it before Superior Court once you exhaust this review.
Item 13.
For the reasons stated, as I look, no response. Delay condoned. They need to be processed and listed perfectly. Take it from it.
Obliged.
10th August. Item 14.
So application notice to respondents, steps being taken by the petitioner, applicant in a period of 3 days, both modes returnable.
Too much okay. 3rd August.
Some details.
Item 15.
You will- Notice. You accept the notice?
My lord.
So and so accepts notice, we shall file with the response to the affidavit.
Sir, you can accept notice on earlier item 14 also. All are railways, one only so this.
14, you can accept notice, we take.
For all.
All right, 14 May, you can only. All right.
On create. Item 16.
Yes. Yes.
Lordship. Delay may be delay may be condoned because they will not be affected. We have made the review, all the party in the review petition, Lordship.
Delay condoned. The review to be processed and be listed.
15 July.
We had suggested you to file a review, no?
Obliged.
That was, the matter was not brought to our notice when we passed the order.
Yes, Lord.
Mr.
22nd.
Mantai will have to look into that.
I have an answer. I'll file out.
You have an answer, but that fact must be incorporated. Let's see.
My lord.
Because there is a.
One is 3 judgments, one is 2 judgments. That is, one is horizontal litigation, one is vertical litigation.
We'll see that.
That will be different.
Obliged.
22nd June.
To our mind, what we have decided is correct principally.
My lord.
But then there is a judgment pointed out by him,
That-
which
that-
says that there should not be unnecessary reliance on that judgment and every fact has to be decided on its own. Anyway, we'll see.
Obliged.
Item 17.
That's with respect to reservation in Assam.
Yes. Women's area. That case is women's area.
Please, my lord.
There was a 40 days delay in preferring this
Mr. P.
appeal.
Roy Chaudhary, yes. Where is Mr. P. Roy Chaudhary? He is not here. Then we'll have to issue notice. Notice. Both modes returnable sometimes in August.
Obliged. 8th August. Item 18.
7 days. You appear for whom?
School education department, the lordship and elementary.
You accept notice on behalf of the other respondents? 1 to 5. 1 to 5.
1 to 4, your lordship.
Notice to 1 to 4. Notice to others shall go on steps being taken within a period of 2 weeks. Both modes returnable July end or August.
7, 8. Item 19.
45 days, secondary CCC. Who? For all others.
Yes, you accept notice.
Lord,
What do you have to say? We are inclined to condone the delay. Do you have to respond? Okay. Take the delay condone. The appeal to be processed. Now I'm looking for full details.
obliged.
8th August. Supplementary list, item 43 for withdrawal.
May I please, Lord, my lord, with petition, my lord, for one of national parties, it was withdrawn yesterday, my lord. So it will become infructuous.
Mr. B. Sinha. You're B. Sinha, no?
Be seen, my lord.
Mr. B. Sinha, learned advocate for the appellant, seeks permission to withdraw this. Dismissed as withdrawn.
Blood.
For admission, item 20.
Well, there is a I for condonation of delay of 48 days. In fact, the appeal was numbered, but there was some wrong on our part. Subsequently, we filed a delay application. The other side has filed an objection.
Dr. Borpatra Goin, you accept notice, and if you have no objection, we'll condone the delay and we'll fix all these appeals.
No, my lord, I have some objection to that. We have already filed the objection, my lord.
That is
For the mandate of the apex court, my lord, 4 of the judgments I'm referring to your lordship. And after that, your lordship will take a decision, my lord.
All right. So you accept notice at least. Accept notice in this application seeking condonation or delay of 48 days.
Yes.
There's an application seeking condonation of delay. So Dr. Borpatra Goin, learned advocate for the respondents, accepts notice and submits that he shall be responding to this application.
Yes, fine.
You have already responded.
They're fine.
Huh? No, you have already responded.
Yes, they're fine. Yeah.
All right, we will take it into account, but we condone the delay. We'll check up the matter.
Fine.
Delay condone. Appeal to be listed. We'll fix it sometimes in July.
Yes, madam.
All right.
So,
July.
hello.
By that time, are you all right? Your eyes are okay?
Slightly difficult, madam, but I'm under treatment. Okay.
All right, July.
Not fine.
Let's hope you're absolutely fit and fine, fighting fit by July.
Mine.
22nd
You'll have to labor in this case.
Yes. Well,
I'm emphasizing we have some objection, but let's see.
yes, madam.
22nd July. 3 along with item 44.
Item? Mr. Das, this will go before another bench.
Friday, not Friday, any other date. After Friday, let it be after Friday.
No, we'll keep it next week.
Next week, better next week.
Let this matter. Let this case go out of our list. And be placed before the appropriate bench. To be allocated by Chief Justice of the Administrative Section.
Item 25.
Wait, please, Your Lordship.
Yes.
It held the judgment passed by learned Central Administrative Tribunal matter.
Yes.
The judgment is at page 68, my lord.
Just give us a minute.
My lord.
Definitely, we could have, contemplated on giving it a relook, the order of the tribunal, but for one reason. That when you were being given temporary status in 2009, you never questioned it.
My,
So how do you overcome that?
yes, madam. I'm coming to that matter. That is the exact point, my lord. The tribunal has rejected on that ground, my lord. Now, Lordship may kindly see,
We also find ourselves stuck at that point.
my lord, I'm clarifying, my lord. But 2003, I was appointed as temporarily appointed as a peon, my lord. On scale, I was appointed. 2004, my lord, I was discharged. Now, that was under challenge in a before the tribunal. And the tribunal passed the order. Lordship, kindly have a look. Page 28. On what ground it was set aside, my lord? Paragraph 7.
Yes.
It was set aside only on the ground that the mandatory.
Read the paragraph.
My lord, from the above, it is apparent clear that the discharge memo dated so did not contain the 14 days notice pay in lieu of 14 days notice as required mandatorily under so. Therefore, the discharge and disengagement of the applicant being not sustainable is hereby set aside in court. The original application is accordingly allowed. The applicant has to be restored back in as a substitute period. The applicant, however, will not be entitled to back wages for the intervening period. So only say that you will not get anything, but the termination was illegal because it was in violation of principle of natural justice or whatever.
On technical ground that you did not have the notice before 14 days.
My lord.
The difficulty is that this reinstatement was, if it was not for back wages, it was also not for the purposes of pension. And therefore, you should have questioned. That's our question. You have given us the factual background.
My lord.
We understand. It's only because of that the problem arose.
My lord.
Otherwise, you would have got into the old pension scheme in either of the circulars.
No.
One which is there in 2000, first circular is of the year 2014, and the other is of 2020.
20, my lord.
You would not have had to travel to 2020 circular. You would have got into this 2014 circular. But even then, at the time of your appointment, you were not directly given the temporary status for for your services to be pensionable. So that decision of giving you temporary status also had to come. But before it could come, try and understand the distinction. Before it could come, you were discharged. And then you remained out of service for 5 years. For whatever reason, for the delay in disposal of the OA or whatever. Now that you were reinstated in 2009, treating this 2009 year as the year of your fresh appointment, and you were reinstated not directly on the temporary post, on the temporary status, but you were first reinstated as an emergency peon, and then you were given the temporary status later.
After 4 months, yes.
After 4 months. So it is not direct. So this temporary status rider in both the circulars coming to your way. This question is that you should have gone to the tribunal immediately challenging that temporary status should have been given to you from 2004 if it was continuous. How do we question this wisdom, this interpretation of the tribunal, which to our mind, it does not appear to be bad at all. It is not perverse.
But my submission is, Marat, I was reinstated in 2009. Now, Lordship can see, I was reinstated for no other reason, but for the judgment of the tribunal, Marat. Tribunal has said it was illegal, but you will not get back wages. Malad, in many cases, Malad, back wage is not given. In many cases, Malad.
In many cases, we are of the view that when such kind of reinstatement is passed, it is said that these services will be treated as continuous. If it were treated as continuous, Malad, you would have been given back wages. That is the law.
But not always given, Malad. Back wage, Malad, in many cases, it's not always given.
Specifically denied for the reason of no work, no pay. But here the difficulty is that you should have questioned it in 2009 only.
But 2009, it was not an adverse order for me. Lordship, kindly see. Lordship, kindly see that order, my lord.
It's an adverse order.
Page 35.
Because your claim is that it should give.
No, my lord. Lordship, kindly see. Page 35, Lordship, kindly see.
Mr. Chakravarti, try and
that order.
We are sympathetic to you. Therefore, we are applying our minds. We are applying our minds to find a way out. The question is that you were ousted from service for reasons which are not known to us. For some reason or the other, you were discharged. That discharge was found to be technically flawed. They asked for a reinstatement. In fact, the tribunal, if we were there, we would have said that if at all a departmental proceeding is to be initiated, it can be initiated now after reinstating it. That they did not do, and you took the advantage of that and you were reinstated. But temporary status was given to you from 2009. This circular is in operation from 2004 or 2014 and 2020, where you know the cutoff date, whether you will be in the net, in the area of old pension or new pension or switchover. Correct. So when you don't question it in 2009, how do we allow you to do it now when you're not being given the old pension scheme?
Regarding grant of temporary status, my lord, I am coming to the point, my lord. In the meantime, there has been number of judgment. I'm replacing one judgment by division motor award, my lord. My lord, the law as of today is that, my lord, numerous judgment by Delhi, mainly Delhi High Court and Supreme Court also. It says, my lord, the Cardinal thing.
Mr. Chakravarti, you will not succeed by putting us in a maze of decisions which are this way or that way.
No, no, only
The
one
law
point,
is
my lord.
very clear.
Only one
When
point.
you are not getting back wages, then it was only the intention of the tribunal to give you reinstatement in service. For all practical purposes, it were to be treated as fresh so far as your pensionary privileges is concerned. Otherwise, they would have talked about 50% of the wages or whichever, because there was no fault of yours. It was not a decision. It was not a decision of your innocence. It was a decision. Reinstatement was a decision.
Technically.
The order was inchoate.
Well,
It was incomplete. The tribunal should have said that if there are charges against the petitioner, let it be reinstated and proceed in accordance with law if so desired. That they did not do. Correct. We are not going to rake up that issue. But you got an employment. I think you have understood what we are hinting at.
yes, my lord. No,
We
that's
give
why.
you one opportunity. Let
my-
the
I
railways-
have my lord, two submission, my lord. I have two submission, my lord. When the tribunal set aside the termination order, my lord, possibly it is not, it did not mean that, my lord, my appointment is going to be a fresh appointment, my lord. It specifically,
This is for the purposes, you could argue this for the purposes of your seniority. Could you? I don't think so. If you, in the meantime, suppose this were a graded post where you would have got some appointment or something. Or maybe with the passage of time, you would have earned some, in situ promotion or something, some monetary advantage. But when you were out for 5 years, you lose out on that unless the tribunal decides that some part of the wages shall be given to him. Nothing of that kind.
Some protection is given, that is senior.
And then where were you sleeping in the year 2009 when temporary status was given to you?
2009, that 2014 circular did not come, my lord. That may have a consequence to that, my lord. I could not have challenged, my lord.
Circular 2014 says that old pension scheme would apply to employees who were granted temporary status before 1st of January 2004. Now, assuming that you were appointed in 2004, where is the document to show that you were given the temporary status?
Exactly, my lord. That is the only point. Exactly, that is the point, my lord.
There are two other points, but you...
The other one, my lord, this is also a relevant point, my lord. My lord, I'll place a judgment before lordship. That judgment of our High Court division may say that law as it is today is that the only question to be considered for giving old pension, my lord, is that when I was appointed. When I was appointed in 2003.
Absolutely, a proposition which has no takers.
And it has been clarified by Government of India circular also, recent circular.
Railways. What do you have to say?
Hearing this
You
case,
would like to respond to this?
yeah, we'll file our response, but this judgment is very clear with regard to the fact.
Not judgment. We have said that. We have
Exactly.
read.
So this aspect of the matter we have dealt in our written statement also. We have filed our written statement clarifying that aspect.
Response to this, we'll see.
Yes.
Yeah. The petitioner joined as substitute emergency peer and later promoted to accounts clerk, promoted to the post of accounts clerk in the North Frontier Railways, Alipurduar division in the year 2003. After rendering approximately 176 days of service, he was abruptly discharged on 31st of January 2004. The order of discharge could not be sustained before the tribunal, before the Central Administrative Tribunal, CAT, Gauhati, which by judgment dated 1st of April 2008, declared the discharge of the petitioner to be illegal, set it aside, and directed for restoration of the services of the petitioner as substitute emergency PM. The petitioner was reinstated in service on 11th of February 2009. However, he was granted temporary status only with effect from 11th of June 2009. That is, when he had completed 4 months from the date of reinstatement. His reinstatement on 11th of February 2009, by virtue of the order passed by the tribunal, was taken as his fresh date of appointment, and 11th of June 2009 as the date of his getting temporary status. It further appears that in the meantime, the government introduced new pension scheme from 1st of January 2004. Options were given to the employees to switch over to the old pension scheme under the Railway Services Pension Rules 1993. The first of such circular was issued on 29th of October 2014. Permitting 2014, putting the employees under old pension scheme who were granted temporary status before 1st of January 2004, but may have been regularized or absorbed after that date. The other circular in that regard came out on 30th of April 2022, which granted one-time option to employees to switch over from new pension scheme to old pension scheme. But that was limited for such employees who had entered service on or after 1st of January 2004, but whose recruitment process was finalized before 1st of January 2004. When the petitioner was granted temporary status after his reinstatement pursuant to the order passed by the tribunal on 11th of June 2009, it was not questioned by the petitioner that the temporary status ought to have been given to him from 2004 only. It was only later when the petitioner wanted to switch over to the old pension scheme, and which request was rejected by the respondent/railways, that he chose to approach the tribunal seeking his incorporation in the old pension, seeking his services to be governed by the old pension scheme, which, according to the petitioner, was due to him for the reason of his discharge order and his remaining out of service for 5 years, having been declared illegal by the tribunal. The tribunal promptly rejected the aforenoted prayer made by the petitioner in the original application. On the ground that while directing for his reinstatement after setting aside the order of discharge, there was a specific direction that no back wages would be payable to the petitioner. which actually meant that the break in service was not condoned, was not exempt from. Which, what did I write in the first? Which actually meant that the break in service for all practical purposes was, or for all practical purposes would be taken into account for pension purposes. Even otherwise, if he were to remain in service continuously since 2004, for him to be controlled by the old pension scheme, his services were required to be made, he had to be given a temporary status before 1st of January 2004. True it is that the petitioner was appointed on 5th of August 2003 and was engaged on 8th of August 2003. But till the time he continued in the service for about 176 days before he was discharged, the temporary status had not been given. In any view of the matter, we deem it appropriate to issue notice to the respondents on the issue whether the reinstatement without any further inquiry would tantamount to holding his services to be continuous since the date of his first engagement. In which case, the decision of the tribunal would be required to be given a relook. Notice to the respondents is accepted by respondents/railways is accepted by Mr.
SP Chaudhary.
Mr. SP Chaudhary, learned advocate, who seeks some time to file his response to this petition by the next date. Re-notify on only on this. Re-notify on. And which judgment do you say that it has to be for? I don't think that's the law.
It has.
It is not the law which has been expounded over a period of time.
It is taken into
Despite
several High Court
become
judgments
very liberal.
and Supreme Court judgment. Our High Court decision. It's taken into account so many judgment.
There's no such university. None be. They'll be rewriting the service jurisprudence. I'm so sorry. We don't know.
If the continuity.
No, you have a look at those judgments. There was. We have. We go by the memory of my brother, which is always correct. This judgment was set aside by us sitting in division bench. Mr. Chakravarti, in that case, we'll be charging you for citing an overruled decision. We may not be very serious about it.
It is overruled.
Seems so. I recall this.
It has relied, my lord, High Court judgment and also Supreme Court judgment.
So Supreme Court judgment would have been distinguished. Anyway, we are not taking a final call at this. Let me respond.
Lordship is fixing any date.
Yeah, we're fixing it.
If the continuity goes, I am out of the court. Continuity goes. But if continuity remains, my lord, then possibly.
Even if the continuity remains, because you were not given back wages. Even if the continuity, what continuity? If you
Continuity is
don't get
2004.
wages, you don't get pension. And you're getting pension to be counted from another day. So you come under the new pension scheme. Heavens have not fallen for you over your head.
That is there.
I don't think so. Anyway, and that advantage you got because of the tribunal, not concluding the order. Anyway, you file your responsibility. For all practical purposes, we have already disposed of the issue, but then let us see what the railways have to say.
Still there is hope, my lord. Hard down.
But then, Mr. Chakravarti, if you find that the judgment which you have cited has been overruled,
I'll check it up.
Please come in the first instance, seek a withdrawal of the case.
Yes.
Item 37.
Yes.
I have.
Let's see our order dated 26/2/2036. PWD Act of 2016. PWD Act of 2000.
Yes, there.
Mr. Nath, no. Have you gone through this judgment? You're also appearing, must appear.
I'm appearing for social justice.
Why, is there anything in this judgment by Justice Pardiwala and Justice Mahadevan, the very voluminous judgment on recruitment of visually impaired in judicial service with respect to this re-verification of the disability benchmark?
I have to go to that. I have not seen.
The question is that now his response is different. In the fresh, after his review is dismissed, he says that we now question the very correctness of the Assam government's OM, the circular, which permits them to put these persons with physical disabilities who have their certificates of having crossed 40% benchmark for a reassessment. Now he says that this power amounts to, changing the entire recruitment process. If it were required, it could have been done at the first instance. Prima facie, we don't agree. If fraud is established, everything vitiates. But, keeping in mind that who are they? They are physically disabled persons, no difficulty. Whether they are above the benchmark for getting that reservation in the job or not, that's the question. But why should it not be done? I mean, that's the question which he will have to argue. But as far as I understand, a very different kind of view was taken by the Supreme Court in this. So let us see. Let's see section 34 first.
We
are not on the exact issue of these individual persons. Whether the government could go for a reassessment, re-verification exercise, and whether they have the powers to do so under the Central Act.
But why we have done so, and the office member we have
Understand.
We are not questioning your. I mean, but we have to go by law, no. Anytime, suppose we conduct an examination process and every screening is done and it is found fit. Later we find that this was fraud. The degree was obtained. Will we precluded from taking any action? No, definitely not. Rajdev Singh versus State of Bihar. Otherwise, all these decisions of the government in fraud vitiates everything. And this may not be fraud simplicity, but then if you procure a certificate, which sees you through the screening process, they give you a higher benchmark which you don't deserve. Can it not be questioned? The difficulty here is that when you start doing it, where is the limit? At what time would you do it? When would you do it? Whether such disability would have improved, which was not there, that improvement was not there earlier in point of time. There are many such disabilities.
True.
So therefore, let us see if something else has to be seen here. Let us not go wrong and go. Just check up, Mr. Nath. We have not been able to go through this judgment of recruitment of visually impaired in teaching service in greater details because it talks about different facts.
I'll see.
Both of you, please,
Yes.
Special Justice Department, Mr. Nath. We keep it for next week.
And my lord, I have submitted a judgment list, my lord. The law has been already, and in PIL, my lord, in Reena Banerjee, my lord, this is a PIL, my lord. That law has been Reena Banerjee and my lord Sujata Bora. The law has been clear.
Mr. Roy, why do you have to be so stingy? You could have brought the photocopies of the judgments along with this.
I will give the compilation by.
And you will give that on our asking.
Yes.
You have done so much of work, you should have given to us today.
And the list is also given.
List you give it to Mr. Nath and Ms. Mapia, but then you give us the judgments, all.
Yes. Compilation.
Compilation you
Yes,
give by
I have,
today.
I have brought mine.
You have got it?
Yes.
Very good. Well, we keep it after 2 weeks.
My lord, so many judgment, voluminous judgment, my lord, in single judge, my lord. Every day I will not get.
No, see, but can we look of a situation where somebody gets his appointment on a fake certificate? Then
No, this is not a fake certificate, my lord.
Let us see, before we adjourn it, where is that circular of the Assam government which says that they have the.
They have changed the policy, reservation policy, man. By 2000.
Reservation policy, of course, we'll be very circumspect about it. No, this re-verification thing.
What is that page? Office memorandum?
When?
By OM by which? they
OM
want
of
to-
2022, which you want to be,
Yes,
which you
yes.
want to be interfered with.
Yes, ma'am. On that page 3. 418.
They're correct. We'll see. Just indicate the page number, we'll see.
Page number? Okay,
480, my lord.
48.
80.
480.
इसको साफ रखो। और कोई दे, हमारे पास नहीं है।
Or my lord, 368.
All right, 360. As jointly prayed for, let this matter come out of consideration. We are keeping it after 2 weeks, Mr.
360. Mine.
2 weeks.
Lot. The date may be fixed, man.
368. Date.
Heading.
It's a, Mr. Nath, why we have deferred it, it's a very sensitive matter. Because the other side is not somebody who can be thrown aside.
Absolutely not. No.
So unless you have the powers to do that,
And
whether the recruitment reservation principles could be changed. If it doesn't align with the central act.
But in fact, our endeavor is to protect the real interest, the interest of the real persons. Lot.
Yes, see, you're talking to a person who has seen fake appointments and day in, day out, we have chased them out by our judicial orders.
Correct.
In some other jurisdiction,
Yes.
as you can know.
And my lord,
We have seen that in TB centers and other centers, they're not even compounders, they were daily wage, village workers, contractors doing masonry work. They got appointed in, TB department and they were administering medicines. All were thrown out, 185 of them in one go. The matter went up to Supreme Court. Rajdev Singh was the state of Bihar number 1, Rajdev Singh was the state of Bihar number 2, and so on and so forth. Same thing happened in judicial, the class 4 employees in judiciary. It should go to the employment, to actual beneficiaries.
Yes. And even.
But then reservation rules can you tinker? Unless that power is there with you.
And
even if the power is there with you, it has to align with the central act.
Yes, my lord.
We'll see.
And my lord, even if I have.
Anyway, Mr. Roy, please reserve your energy for next day. Let us also come. Then we'll be able to appreciate your arguments better.
Item 38 and 39.
12th of June.
Basically.
Not any.
Huh?
24/6. We'll come back after 5 minutes.
Item 38 and 39.
This is ICDS.
Yes, Lordship.
Let's see the last order. Just give us 2 minutes.
Yes, Lord.
Yes.
Lordship,
There are some piecemeal orders.
Yes,
Which
Lordship.
does not take into account, to our understanding, the direction of the petition. There are many other things.
Yes.
So, yes, Mr.
Lordship, already we have filed our affidavit, Lordship already have it in record. So in that affidavit, we have made it very clear as regard the first one, the first item number 38. Here, 3 centers have been shortlisted and now those 3 centers are working properly in LP school. And now land has been searched to have a permanent center. And the beneficiary list has also been made. So today.
Is your affidavit page?
In the affidavit, we have made it very clear because.
I'm asking for the page.
19-2,
Yes. Page,
247.
yes. Let me go to page 249.
Yeah. Mr. Barua, we are not concerned with the names of the centers or names of the areas where there are no ICDS implementation, where there are no Anganwadi centers. They are on a general proposition. Now, the petitioner has just flagged few instances. We would like to ask you, we would like to have you respond to a situation when we say that have you covered the entire state of Assam? Has it been implemented in accordance with the rules, the norms? Have you stated for it? Have you given proposals to the central government? Have they responded?
They have.
It is not only with respect to Jungle Line 1 or Itapur or whichever. What Ms. Ghosh has done, she has only flagged the issue. Now, we are not concerned.
She has flagged the issue with regard to 3 centers.
Well, suniye to sahi, Mr. Parwar.
Yeah.
We are not charging you with not taking interest in the matter. We are only asking you to recalibrate, refocus on what we want. This PIL is all right. There are certain specific instances quoted. We are not on that. Now, there could be some reason that 365 families, 467 families, they are not covered under the ICDS scheme. So some recommendation made, that doesn't satisfy us. Now, it's not our satisfaction, it's a constitutional mandate. Correct. So the proposals have to be sent by you and has to be responded by Mr. Chaudhary. Are you sure that it has been done for the entire state of Assam? The length and breadth of Assam?
For that,
And then this kind of affidavit, if you say that we have very categorically stated, I don't consider this a statement in your affidavit to be of any help to us.
Also followed by that affidavit today, I have given the latest status.
Where is that?
Already I have submitted, yes, as regard PL number 39. This is with regard.
Again, we said, no, we are not concerned with prayer number 39 or 40.
Yes.
We are concerned with general implementation.
Yes. So since we are concentrating presently on these 3, so I've just given the details and data as regard the beneficiaries which have been shortlisted and also the 3 centers which are already being marked and they are functioning. And we have gone for a
give us a comprehensive status.
Overall
status.
Understand.
We understand you have written for these 3 centers. They have responded favorably, schools and all that. But then we want it for the entire state. Don't remain focused on what Ms. Ghosh has said.
Yes.
Respond to us. Don't respond to the petition.
Yes, I understand.
Respond to us.
Even though she was concentrating only to a limit.
It is her duty to focus, to flag certain issues. But we are taking it in a holistic manner. That doesn't satisfy us. If you want us to close the PIL only because you have recommended for 3, I don't think we'll be doing a great job.
Yeah, I understand. Lordship has wanted as regard the whole of
a status, any requirement of fresh Anganwadi centers? If yes, then whether you have sent it to the ministry proposal for the central government, then only we can ask Mr. Chaudhary what is their stand.
Last year,
You have asked me.
And Lordship, one thing I just want to point it out where they have submitted, they have given the proposal for, but they have not, the beneficiaries have not received the take-home ration or hot cooked meal, which they are supposed to get.
This is what happens, no?
As per the mandate of the National Food Security.
Starts responding to these, isolated instances. Now, only making an Anganwadi center, would it suffice? It would not. Unless you provide the nutrients, unless you ensure, unless you monitor, unless you do. Child CDPO. CDPO, if the CDPO is not there, Anganwadi worker is not there, all litigations come to High Court, even for appointment of for Anganwadi worker, that whether she is she's of one particular community, not from the dominant community, number was more. I mean, all this keeps it vacant. So therefore, Mr. Barua, we are not asking you to respond individually. We are asking for a general status, and we will say that this is the public interest litigation. You see, the earlier orders which I have found, these refer to your response to the specific instances. That's not the purpose, according to us.
Yes.
That's not the purpose of entertaining a PIL. If we entertain the PIL, it should not be limited to one particular jungle line of teacher or something. We entertain it because this is illustrative. You give us the update. Don't go by what has been cited here. Take down freshly. A final year law student has preferred this public interest litigation, seeking judicial intervention to address the so-called systemic failure of the agencies in implementing the Integrated Child Development Service Scheme and the provisions of the National Food Security Act of 2013. Though in the petition, there is reference of 5 remote villages where there was, according to the petitioner, no Anganwadi centers which could serve as grassroots delivery point for ICDS services, thereby depriving the vulnerable groups of essential entitlements, thereby depriving the vulnerable groups of essential entitlements of supplementary nutrition, health checkup, immunization, preschool education, ration, take-home ration, etc. The contention of the petitioner is that with this practically no implementation or at best faulty implementation of the ICDS scheme, directly leads to malnutrition, health risks, which in a large measure marginalize women and children who need immediate succor. The relief sought in this petition is a mandamus directing the authorities for immediate ICDS implementation. Semicolon, Anganwadi centers to be set up as per the population norms and making provision for free meals and nutritional support. the affidavits filed on behalf of the estate of Assam to reflect that efforts are being made to rectify the situation by proposing to build Anganwadi centers in places where there are none. But according to the petitioner, according to the learned advocate representing the petitioner, construction of an Anganwadi center would be of no avail unless the beneficiaries are provided with these services associated with ICDS and National Food Security Act. Under such circumstances, we direct the estate of Assam to the Women and Child Development Department and Panchayat and Rural Development Department to apprise this court as to the current/present status of the implementation of the scheme, meaning thereby that this court should be informed whether there has been a rational rolling out of the schemes under the acts referred to above for the benefit of the vulnerable groups. This court would also like to know whether there are any places in the state of Assam where there are no Anganwadi centers as per the population norms. The other information which this court would ask for is whether the nutrients and food items are being supplied to the center for it to be disbursed to the needy. The status of schools providing midday meals to children is also required to be monitored by the Family and Welfare Department, by the Women and Child Welfare Department. A detailed status report, Mr. Barua, learned advocate for the state, submit shall be filed positively by the next date. We are giving you 8 weeks. Give us a detail.
Yeah.
Correct. And don't just limit to few proposals that you have made to the central government and how they have responded. That doesn't satisfy us. Otherwise, everything is done. If you're looking at only 5 remote villages and 5 centers, then we can close this case.
Because initially the petitioner was only concentrating on 5 villages. That's what we have answered.
Now, therefore, we have, The prayer was that it was only an
It has
illustration.
widened now.
All right.
Deeply.
12 August. Item 40.
Yes.
Can you see the last order? 33/2026.
Which orders?
33/2026.
For the absence of learned advocate general, we have showed the verified Now, why do you want to show this order to us? Why do you want to show this order to us?
That is why I did opinion the detail order of past file on 28/2026 number. About the
The advocate general was here in the morning. Whom are you appearing for, gentlemen?
Private respondent.
You're appearing?
Respondent number 6, madam.
Private respondent.
Private respondent.
Yes, you need to. Mr. Barua, the advocate general had to take instructions from the government and had to clarify what is being done for declaring a particular Anganwadi center as a predominantly dominated area of which caste, civil caste or non-civil caste. Now, the whole issue, the whole controversy hinges on this. So he had assured this court he is not here today. Take instructions from him.
After completion of process, minute of paper.
Hmm?
After process of
That we understand, but for future also that's.
After completion of process is one thing.
yes,
You
madam.
know, if there is no clear stand, the assessment, why should we not justify? And if we justify it, then your appointment, direction for your appointment would be under cloud. Because he represents the SC candidate who was appointed. Then on a slender ground, the single judge, ousted her.
Merely on the basis of my letter of the
Whatever merely on the basis. Anganwadi center,
Panchat secretary.
only because you secured more marks, you would be a better Anganwadi
No,
center
no.
worker. Absolutely not.
Not madam.
You're not required to teach as an Anganwadi worker.
But the area is so far, subsequently I have come to know.
Correct. So we would like to know the stand of the state. Now, the census was of 2019.
Right.
And the decision was taken much later. That is the issue. Mr. Barwa, you are not aware, therefore you are having that deadpan expression.
Yes, Mr. Das, what is your instruction? It is scheduled caste dominated.
No, my lord.
No.
No.
According to you.
No, correct.
Not, my lord.
You would never
Because
admit
center is itself Anganavar.
admit that. And for all these centers, there can't be a census that it's dominated by which community.
Kolita para
There has to be a
Anganavar.
general assessment,
Yes.
or there has to be a change in the recruitment rules, engagement rules. Or otherwise, the marginalized community. I think this is the only way in which you can filter it down.
Name is itself belongs to the general caste category.
That will not.
That will not do.
That
will not do.
They are really Kolita Kosi inside.
Yes.
No,
No, I have come to know the
they are in the
population pattern.
Kolita Kosi
Yes.
near Hajur. And you know the population.
And
Anyway, you take instructions from the learned advocate general.
Yes.
We are giving you 2 further weeks.
Yes.
The difficulty is that she has been divested of a job on the ground that she does not belong from the community which has a dominant presence there.
Got it.
Under what authority, under which rule? Who decides? Is there an official report? So if that is not there, then why should we not go by a candidate who comes from the marginalized community? That would be a safer option. That's the question which we are confronted with. Here, Mr. Barua, learned counsel for the state of Assam submits that he shall take instructions from the learned advocate general and shall get back to this court in the medical state.
Borua, go to have a downloaded copy of order dated 28 one.
Yeah.
15 July. Item 41.
Borua. That's what we're gonna-
Are you sure?
No, it's not.
No,
Usually, yeah.
very sure. No, it's yes.
Well, I seek short accommodation to file my affidavit.
In which matter, sir?
41, because I'm for the respondent number 5. This is that matter between 2 banks, the mortgage issue prior to that issue. My affidavit is ready, Malok. File it maybe within.
And which rule would apply here?
Malok.
See, a property has been, same property was mortgaged with 2 banks.
Yes.
For 2 different loans.
Lordship.
Both loans went bad.
Lordship.
Now, Canara Bank proceeded first.
Proceeded first. And they have sold the property to the auction purchaser. An auction purchaser, Malok.
So what is to be done now?
Malok,
Can the auction purchaser be kept on hold? He has spent money.
No, Malok, the issue here is that the property, Malok, was sold and the possession has been handed over. Now, the only ground on which the district magistrate.
The only is that you have not done your field work while granting loan.
No, Malok, I am the prior mortgagor. They are the subsequent mortgage. That is an admitted.
They approached Sarfesi first, no?
Sarfesi, Malok, that depends, Malok. No. They were lucky perhaps to find a good.
Anyway, we'll see. Let's see who appears for the auction purchaser.
Auction purchaser.
Why don't you come? Your interest is paramount. These banks, they keep augmenting the business by affording loans to people. But you have purchased without knowing.
But if
the same property was sold, mortgaged by the owner with 2 banks and 2 loans were taken. But you have purchased it. There is no fault with you.
Yes, that's it.
I have filed my affidavit.
We are looking at your interest now, more than the banks. Correct. So we'll find out the law. Which law will prevail here?
I have
Which
filed my
rules?
affidavit already.
It's normal in this case, the stand of the petitioner bank is that the claim could not have recalled the order. In fact, this is not a case of recall of order.
Once the order under section 14 was passed by the collector, once it was sold, once everything was done, the district manager or whichever authority could not have recalled it. That's prima facie the idea which comes to us. But let us hear you.
Our stand will be slightly different now.
Let's see.
I'll file my affidavit now.
You are in position.
Lordship.
Only mutation remains.
Only mutation.
Only the mutation is.
Only.
Mutation is
25 lakhs already.
You are Mr. Ganguly.
Lordship.
Mr. A. Ganguly, learned advocate for respondent number 5, submits that he shall be filing the counter affidavit by the next date. Let such an affidavit be filed positively on or before the next date with a copy served in advance to the learned counsel for the parties. We give you 2 weeks. Just have a look at it, and we are more concerned. Let these two banks fight amongst themselves. We don't know. But you should not be in trouble. Unless you make a prayer that the authorities be directed to return your money, and you keep your hands off this. Don't try and fish in troubled waters.
Yes.
If you're interested in that, we can ask it to be done. That sword would keep on hanging on your head.
Value of 6.
There
Item 45 supplementary.
was an interim order, Lordships had passed earlier. There's an interim order that was passed earlier.
Interim order, if any, there'll be a change in the date. We'll just let you know.
28th July. 28th July.
28th of July.
20th of July.
Interim order, if any, in the meanwhile, shall success.
Item 45.
May I pull the lunch?
Supplementary.
Ashim, here in this case,
One second.
Yes, ma'am.
The National Highways Act of 1956, whether the appellate authority, the competent authority, can exercise his powers of his own, or it has to be referred.
The civil.
Yes, my lord. Principal judge, we court.
Additional distribution. And we will refer the two options in there. Therefore, we dispute the position to the principal civil court of original process. But the amount determined. We cannot. Even if we pass it, because there is a dispute. A dispute arises. So dispute is.
One is in dispute under 3Z. 3Z says.
Just read 3G of the act.
3G5. If amount determined under success is not exceeded to other. That is determination of amount payable as compensation. Is not that. Here three ways. Who's principal, so once it is determined under 3C, no dispute. The party will go to the promotional committee for having jurisdictional petitions. So, and that is the. He shall refer the dispute to the decision of the civil court of law. उसके प्रश्न में उपयोग करना
Mr. Barua,
My lord.
you have to tell us, because the plain reading of section 3H subclause 4 says
My lord.
that if any dispute arises as to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority, which in this case is the additional district commissioner.
Yes, my lord. There is a appointed, competent is being appointed by central government.
Please hear out where we are stuck. Any competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction.
My lord.
So therefore, by the impugned judgment, Mr. Chaudhary has been referred, Mr. Chaudhary has been asked to go before the court of original jurisdiction, principal civil.
It is.
Can he go of himself? No. He has to first apply before the assessing officer, the additional district commissioner.
Whichever my lord, but generally what happens?
He shall refer the matter.
Yes, that can be also because. No, not that can be. Mr. Borua, here, my lord, the dispute was raised before Kala. Then instead of referring it, he passed the impugned order dated 27/6/2025.
He is determined. He is determined. So in this case, he has to record on the asking of the party who is aggrieved. Yeah, were you there before the officer? Were you there before the officer?
No, Lordship, what has happened, this particular order was passed.
Without notice to.
Exactly. Because the entire process was.
Set aside that order,
Exactly.
set aside the High Court's order, and then we remand you there.
Exactly. That was the limited prayer was there on my part, Lordship.
Here, my lord, only my humble prayer before Lordship. Because due to this petition, though there is no stay or nothing, admission also not there. But they are not giving, this Kala is not handing over physical possession to us.
We are concerned with that issue.
No, that's my concern is because we are unable to go for construction, my lord. Thereby,
you would be absolutely happy in no party being paid.
No, that but we are not
concerned
because
with your happiness. We are concerned with implementation of
being a council of NHA, I'll be happiness once I go for construction. Where I'm struck up because of we don't given a position certificate, but physical position is not given. But as your lordship award, lordship gives limited time then because we are stuck up. Public interest and other public stakeholders also involved here.
You have consumed the land.
No.
Where is your interest now that the party should be paid? You are very happy because mother and son are fighting.
That is our concern before lordship because they have not given us physical possession.
Anyway, we are not in line with, we are not in agreement with the order passed by the learned single judge. Nor do we approve of the additional district commissioner deciding the issue. Because if there had to be a notice to him, and if he has not been noticed, where would be the forum for him to ventilate the grievance? And once he ventilates the grievance, the matter has to be referred to the judicial side, to the jurisdictional judge, principal judge of the jurisdiction. That's what the section says.
That's all right.
Because there is no dispute with respect to determination.
Exactly.
Just a minute. Is not acceptable to either of the parties. The amount shall, on an application by either of the parties, be determined by an arbitrator to be appointed by the central government. Or the other option is that under 3G5, you can apply for arbitration.
Arbitrator. But that is by
Now, one
the,
second, let him take a call. What do you want?
me. Acha.
No, Lordship, it is
amount.
it is not with regard to the amount, Lordship. It's the apportionment of the amount.
Determination of amount.
This four will come here, Lordship.
No, no, the here the dispute is with us.
This is apportionment.
The apportionment of the amount. Lordship.
One is 3G.
Exactly.
Determination, other is 3 is apportionment.
Apportionment of the amount.
Yes. Apportionment you will do because you have to decide the right to amount.
No, no, determination of amount, they will
Yes,
compensation,
up to-
this is a portion.
Apportionment, Lordship.
Then I think the only authority which can decide in case of dispute is
Exactly,
principal
Lordship.
chief.
Exactly.
Take it. The appellant has questioned the judgment dated 22/8/2025 passed by a learned single judge in WPC number 4853 of 2025. Thereby relegating the appellant to vent his grievance before the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land was situated, the land which was consumed was situated, is situated. To recount the facts, in short, the appellant as wife of late Parma Kalita had constructed a house over the land belonging to her husband after taking due approval from the authorities. Her contention primarily was that the other heirs of Parma Kalita, namely his sons and daughters, had succeeded, had received lands as class 1 heirs. For the land which was acquired from the National Highways issued notice to the appellant for payment of compensation, pursuant to which she had submitted all required documents, including proof of construction of an RCC building, along with the permission and a lease deed showing that the building was rented out. However, it appears that because of some objections by the sons and daughters of her late husband, particularly respondent number 5, what did I say? The compensation was not paid to the appellant. The appellant appears to have filed a detailed written objection countering the claim of respondent number 5 and others. The grounds raised in such counterclaim, grounds raised in such written objection was that after the death of her husband, all other legal heirs had inherited the land and that she had constructed the building with valid permission and no objection certificate. So based on these two fact situations, the appellant claimed that she had an absolute right to receive Ziraat compensation for the structure. It further appears from the records that the additional district commissioner had sought an information from the circle officer regarding the possession, as also Ziraat compensation proposal in the name of the appellant. The circle officer, however, submitted a report ostensibly after a field verification that the land was in possession of the respondents. The appellant claims that such verification was done in her absence and without even notice to her. However, relying on such verification report by the circle officer, the additional district commissioner rejected the claim of the appellant of receiving Ziraat compensation for the structure. This decision of the additional district commissioner was challenged by the appellant before this court, as referred to by WPC number so and so, by WPC number 4853 of 2025. The learned single judge, on the ground of alternative efficacious remedy to the appellant, dismiss the writ petition, directing her to approach the principal civil court of original jurisdiction in accordance with Section 3H(4) of the National Highways Act 1956. In case of any dispute regarding the determination of amount payable as compensation, the claimants have a right to have the issue decided / determined by an arbitrator to be appointed by the central government in accordance with Section 3G subclause 5. In case of dispute over determination of shares amongst claimants, the competent authority, which in this case is the additional district commissioner, is required to refer the dispute to the decision of the principal civil court of original jurisdiction within the limits of whose jurisdiction the land is situated. There is no provision under section 3H4 of the aggrieved party directly approaching the principal civil court of the original jurisdiction in case of being dissatisfied, in case of a dispute raised with respect to the determination of shares of the compensation. Under the aforenoted circumstances, we find that the correct course for the district, for the correct course for the additional district commissioner, bracket में काला, was to refer the dispute before the principal civil court of original jurisdiction, rather than determining the issue and rejecting the claim of the appellant. We are also not in agreement with the reasoning of the learned single judge of the appellant not having exhausted the alternative remedy available to her under section 3H4. This reasoning was based on an understanding that in case of any dispute after the determination by the Kala, the forum to challenge the same would be the principal civil court of original jurisdiction, which is not correct in accordance with the scheme of the provision. Left with no other option, we set aside the order passed by Kala as also by the learned single judge, which has been impugned in the present provision, and direct that in the event of the appellant approaching Kala with her objection with respect to allocation or with respect to apportionment of the compensation amount, the Kala would issue notice to the other claimants, whereafter the matter shall be referred to the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land is. The land is said to be situated. It is expected that such decision shall be taken by the competent authority on land acquisition, bracket Makala, within 4 weeks of the appellant approaching it.
Private respondent is here.
Yes, private.
Since Mr. So-and-so, appears for respondent number 5, he can also appear. The respondent number 5 and other claimants also could appear before the Kala and have the matter referred to the principal civil judge of original jurisdiction for proper apportioning of the shares in accordance with their entitlements. The appeal stands allowed to the extent indicated.
Obliged, no.
Okay. What is this payable?
This is pharmacy.
Who appears in the next matter? The pharmacy council. Yes. All right, after lunch. But why do we, Mr. Mahanta, why do we entertain this petition?
My lord.
You say that you have learned about it.
Yes.
Uh,
From the
newspaper
newspaper.
reports.
Yes, my lord.
No? Why do we get into all this?
No,
Give us
later
a
on,
definite information on affidavit.
My lord.
What is this information?
My
We're
lord,
not going to
later,
make a roving inquiry with respect to this kind of an allegation.
my lord, later on, I obtained the RTI information, my lord.
Where is that?
Only there.
No, but how could you find this and how did it cross the screening of the committee which vets it? This is based on some stray information.
My lord.
Somebody saying that we have information that war has begun.
And in fact, we have all sorts of minor function. Why this one? I am representing one of the college, my
You
lord.
can withdraw this petition like your counterpart and file a fresh petition if so deemed necessary. I mean, we would ask you, what is the basis?
My lord, the first initially, my lord, it was a newspaper.
Sorry, you give illustrative instance, you say, and we will make you, you'll have to specify that this is the information according to your
My lord,
knowledge.
the RTI info.
Well, let us see the oath that you have attached with this.
My lord, the my.
Just a minute.
My lord.
The
last page, page 35.
This is, aren't you being irresponsible in doing this?
But whatever document I relied, my lord, this is palpably clear that without the NOC, my lord, they have started the
Knowledge.
my lord.
And suppose this knowledge
But
this
the RTI
statement appears to be wrong, then?
From the RTI, my lord, I obtained the knowledge, my lord.
No.
And my lord, one thing, my lord, whatever my learned friend is submitted, they
Why do we, we did not look at this. This is all based on your knowledge about newspaper. And this has been continued for so long.
This is subsequently on the basis of the RTI.
Sorry.
My lord, one aspect, my lord, only lordship, this means no doubt.
This issue could be a very serious one. Yes, we understand that.
Yes, my lord.
This issue could be a serious one, but then not on this kind of information.
My lord, the Supreme Court already decided in the Pharmacy Council case, my lord, that the pharmacy is the absolute, they are the only absolute.
We are aware what Supreme Court decides.
My lord, one thing, my lord. Lordship, my lord, maybe allowed, my lord, something like that. My lord, whatever, my lord, my.
Cross that hurdle, Mr. Banda, that we, what
My
is
lord,
the rationale for
one aspect, my lord, only one aspect.
Yes.
My lord, my lord, trend is whatever they were submitted. They have regularized the, but that is all, my lord, is subsequently issued and giving a retrospective effect, my lord.
Correct.
This is very dangerous, my lord.
You may be modest in your approach. Your prayers may be very modest, but why do we accede to it? No, we'll do it of our own if we feel like that. Or you file an affidavit saying that from this source I learned. We will straight away.
My lord, I'll to that effect, man, I'll find.
File an affidavit.
My lord.
Bring on record the RTI information.
Yes, my lord. Earlier RTI information I have annexed, my lord, here.
But why do you say that it is based on your knowledge?
No, not only knowledge, my lord, the RTI, this is whatever, my lord,
What
I,
is the RTI information?
RTI information, my lord, I sought from the, my lord, Pharmacy Council of India and the Indian Pharmacy Council, my lord.
And what does the pharmacy?
They are not able to give any information. Then I searched in the website. Then from the website, I obtained the copy of all the copies, my lord, regarding their default and the regularize the provision before starting the course, my lord. This is my case.
Who appears for Pharmacy Council of India?
State, I think, Mr. Gogoi.
And who appears for the two universities?
IIP. Well, we have issued the, my lord, affiliation, my lord, as per the norms. my lord.
That's right.
In fact, my lord, we have filed an affidavit. There is nothing from the side of the writ petitioner till today showing that, pointing out that these are the irregularities that have been committed. All the colleges have filed their affidavit. There is nothing from his side.
I have filed reply.
Just in air, my lord, this
Mr.
PIL has been filed.
If your information is found to be incorrect, we'll be imposing heavy.
My lord, I ready to, my lord, accept whatever lordship will.
Respond to their statement. Say that the statement made by Mr. Gogoi and Mr. Chaudhary is incorrect. This is the institution.
My affidavit reply, my lord, their reply, the affidavit was filed by the respondent number 1. I have filed the reply.
Page?
That is, my lord, it is not compilation. This is, I am saying, my lord. This page 477, my lord.
Page 477.
In fact, my lord, Pharmacy Council of India supported me, my case. In para 3, my lord, I have specifically said that they have supported my case from the Pharmacy Council of India.
Where is your statement with respect to particular colleges?
My lord, yes, my lord. Their affidavit will counter to their affidavit.
Why are you giving us the regulations and the necessary prerequisites for running a course? We understand that. We have that. I don't know whether you are understanding our anxiety. This kind of PIL is, I mean, you may feel bad about it, but we will call it frivolous. Where is that statement? Which college is taking admission without affiliation, without permission?
Yes, but I have in my PIL specifically said that without taking any NOC and
My lord, specifically show us your materials to have a satisfaction that these colleges are being run without that.
Yes, well, then the PIL, my lord, the copy of the PIL.
No, give us the specific names. Don't ask us to shove through the pages. You give us specific names of the colleges.
Yes, well, I have given you a specific name, my lord.
Boli.
Kindly look at page, my lord.
You read it out.
My lord.
If you take name of any institution, we will ask Mr. Gogoi and Mr. Chaudhary to respond to it, and we will also make him a party.
Yes, my lord.
Do that.
They have responded, and I have filed in counter also, my lord.
Okay, show us though. What are the violations after all these pleadings?
Yes, my lord.
That they cannot run in terms of the.
Yes, my lord.
And
Yes, my lord. Then my lord, lordship will come to the my lord affidavit filed by the respondent number 3, my lord. This is the Pharmacy Council of Assam, my lord. How they have regularized the things, lordship will come to my lord.
They have regularized.
Yes, my lord. This is annexer, my lord. This is
so now that they have regularized,
yes,
and you had modified your prayer that you only want regularization.
Then I file an effective IA, my lord, that this cannot be taken during the course of the, my lord, the case, whatever that is pending, because they have already committed irregularity, and that cannot be regularized by passing a separate order.
You are expecting us to pass an order that despite regularization, the students who have paid money should be asked to go back home.
No, I am not on that, my lord.
Then what do you want?
Whatever they practice the irregularity, that is I on that. Because I have because
we will take their statement on record that they shall be careful in monitoring such institutions, and they will ensure that without proper affiliation, without proper permission, admission is not taken. That's all.
My lord, then my lord, kindly come to my one intellectual application where I have specifically stated, my lord.
You dispute this, that it has been regularized.
No,
And
it is-
permission
I
has
am
been
not
done.
disputing, my lord. Thing is that whatever already done illegality, that cannot be, my lord, regularized by doing another act, my lord. This is the thing, my lord.
This is Mr. Mohanta, then perhaps you.
Or which, my lord, they have to be given some,
are
my lord.
absolutely unaware of the development of law in this regard. Now, this concerns the students who have undergone a course after spending money. Now, this had to be regularized. We would not ask them to be left high and dry.
That is,
This is not something novel. This is not because of our benevolent approach. This is what the Supreme Court has done.
My lord, I am very much appreciate these things, my lord. But thing is that whatever they, during that course of time, there was no source of regularization, my lord. That is my case. So without having that NOC approval.
Now what do you suggest? All right. You want a certification from us that because of your flagging this issue, everything was rectified. You want this?
But they, without the leave of the court,
We might.
but without the leave of the court, they have rectified, my lord. This is the thing. During the pendency of the case. Then notice, yes, my lord. Yes, my lord. Yes. That is, my lord, they backdated, they have issued on the day of, my lord, whenever I obtained your RTA, my lord, there are no such of NOC, my lord.
File a statement that it has been backdated. Only
My-
because the
this is my
petition has been filed.
IA, my lord.
Then we will deal with it.
Then I have filed a IA, my lord, for detail IA regarding these things, my lord. Whatever they have done, IA, my lord.
IA for what?
IA for, because they have, whatever they have taken.
What is the prayer in the IA?
IA, my lord, that cannot be done subsequently, my
No,
lord.
prayer,
Whatever-
that cannot be
Yes,
done
my
as
lord. All right.
submission. What
Yes,
is the
my lord.
prayer?
Yes, my lord.
Are you running an please don't take otherwise. Don't take us amiss. Are you running any pharmaceutical college?
I have, whatever is my status, I have understood.
All right. That also is a fact which has to be
Well,
to be
my
verified.
IA, my lord, prayer was that in this premises, you therefore prayed that your lordship.
If you
that this is-
remember correctly,
My lord,
you as a college owner
I'm
had
not a
come up
college.
with a case.
I am not another
You were
case.
not there.
Another case, my lord.
In another case.
But this is, I'm not college owner, my lord. This is, I'm coming on, my lord. This is also wrongly, my lord, shown that I'm a college owner, but I'm not a college owner, my lord. This is also coming.
This
Giving
is-
the affidavit to
this
that, I
is
think.
of eliminating competition.
No, my lord, this is not there.
There's no way of eliminating.
So I try to bring, my lord, some.
You appear in one case. We hear hundreds of such cases. It is not very difficult for us to, lift the wheel and see what's happening. But this kind of submission.
My lord, it is not
that
my.
it was rectified now only. And do you really find it an infraction of law that because a petition is pending, they needed the leave of the court to rectify it?
No, my
Are
lord.
you suggesting this?
No,
line of
I,
thinking?
my lord, content is a little different, my lord, because my, I am saying that they have, my lord, rectified it, is okay, my lord, this is no problem, they rectified the prayer period also. But thing is that, my lord, the way of they are doing these things, but this is my own.
What kind of public interest is this, Mr. Mamta?
My lord, if I not, my lord, brought these things before the lordship, that would not have happened, my lord, because that will be continued without the NOC.
So that is what we are asking you. You want a pat on your back. We will do it. Don't ask us to get into all this.
No, my lord, this is, it is.
We say that because of the efforts of Mr. Mohanta, now all irregularities have been. What kind of
In 2019.
And you are asking us to reject all those NOCs.
No, I am not.
That is your prayer in the IO.
No, because subsequently that cannot be, my lord. Subsequently,
is
permission of the court, my lord, that can be, my lord. But thing is that whenever they are doing these things, at the time the matter was going on, and by it way of affidavit, they have brought this thing. But at the time when I procured my copy, this is unavailable in the website. This is my case, my lord. How they try to cover the all, my lord, things, this is, I brought before lordship. This is only to be considered by your lord. I am not that that's to be rejected, but there is a way of these things, my lord.
All. We have heard Mr. P. Mohanta, learned advocate for the petitioner. Next, there's public interest litigation. flags a very serious fact that there are several private pharmacy institutions in Assam who are illegally admitting students in the B Pharma course without obtaining the mandatory no objection certificate or approval from the state government before starting the admission. The further contention of the petitioner is that those institutions, bracket response number 7 to 12, were granted only temporary affiliation for a year or two, by two of the universities acting as examining authorities, namely Srimanta Shankardev University of Health Sciences and Assam Science and Technology University. Bracket response number 5 and 6 respectively. The contention of the petitioner initially was that such admissions violated the specific rules of Pharmacy Council of India and the Bachelor of Pharmacy Course Regulations 2014. Requiring prior Pharmacy Council of India approval for starting a college and taking admission of students. A concern was shown for the students who normally would pay heavy fee without being aware of the irregularities in running the college or the course, which ultimately may lead to derecognition of such colleges, leaving such students absolutely high and dry in the mid of their career. The issue, no doubt, is a serious one, but it appears from the records of the case that most of the colleges about which this complaint was made have got their affiliations. The grievance of the petitioner is that only when this public interest litigation was filed, that hurriedly all the irregularities were rectified, which was a post-haste decision. And to a large extent, such rectification is not permissible under law. This submission is based on, in our view, not on public interest, not in public interest at all. There is no gainsaying that institutions ought not to take admission without prior approval, without prior statutory approvals. But when the defects have been remedied, it would be no public interest that those students face the brunt of derecognition of such colleges. The specific statement made on behalf of the universities referred to above, bracket response number 5 and 6, and the Pharmacy Council of India is that none of the institutions named in the petition are running their courses without proper approval as on date. This is good enough for us to close this petition, but with a direction and caution that the universities, which are the examining bodies, ought to be careful. Ought to be careful in continuing with such affiliation of such universities, of such colleges, which do not have the prior approval. It is also expected of the Pharmacy Council of India to properly monitor the running of such courses by private institutes. The petition stands disposed of.
But except respondent number 9, my lord. Respondent number 9 has not been allotted NOC by the government itself. In fact, the litigations are pending, my lord, before the honorable court as well.
Yes,
Except 9. We have stated in our affidavit.
Mr. Mahanta, learned additional advocate general, however, has submitted that. Sorry, Mr. Gogoi, learned additional advocate general, has submitted. Like, see, these titles are so common. No, Mr. Gogoi, learned additional advocate general, has, however, submitted that no affiliation has been given to respondent number 9, which fact does not stand disputed.
Delhi pending in Delhi. Are disposed.
So we are not saying anything against you.
Why not given?
We are not saying anything against you. Don't have it left open for Mr. Mohanta to unnecessarily.
So, my lord, the affiliation, my lord, that is given only to 8 and my lord 11 for 1 year, not to all, my lord.
Next.
It is affiliation, my lord, only 1 to 8 and 11, my lord, only for 1 year.